All right, ladies and gentlemen, we're going to go over chapter 13, which is the courtroom, the pretrial and trial process, which is a very fun part for me because I am a criminal trial attorney. So, of course, this is the fun part. So, we get to talk about the rights that attach and kind of the roles um, of the parties involved in the trial process, and that's pretrial and trial. So, as an introduction, the pretrial and trial phases of the criminal justice system strike a balance between the efficient prosecution of criminal offenders on one hand and democratic participation in the criminal justice system and the protection of defendants against unfair and arbitrary prosecutions on the other hand. So that was a lot. So we're going to talk about that. So the biggest thing you heard is the democratic participation or process, where you as citizens get to be a part of it. So we'll talk about that a little bit more. First, the preliminary hearing. The preliminary hearing is a mini trial in which the magistrate or judge determines whether there is sufficient evidence to bind a person over. That means to move the case up. Um, the defendant to bind over the defendant for trial or whether the defendant should be released. Um, so of course that's when they're in custody. Then you also have a preliminary. I mean, a preliminary hearing is not constitutionally required. In indictment states, and that we'll discuss what indictment means, but that's the process of a case getting moved up to superior court or to the felony trial courtroom. Um, In indictment states, the prosecutor may bypass the preliminary hearing by taking the case immediately to the grand jury. In information states, the prosecutor may file an information, which is like a document that where the DA is requesting to move the case up, and may bring a charge either before a preliminary hearing or before a grand jury. So, information and indictment are kind of the same process. They're just called different things, different jurisdictions, but it's the process in which the DA, the prosecuting attorney, brings his case either in a preliminary hearing or before the body of a grand jury, which we'll talk about what that is. And that grand jury, that body determines whether there's enough for the case to go forward or whether it should be either dismissed or at least deal should be made or it should kind of be dropped or whatever, reduced to misdemeanor or something like that. So we'll talk about that process. So you heard me say grand jury, so let's talk about it. Grand jury. The grand jury is charged with the responsibility for determining whether to indict, which means that they grant a true bill of indictment, which says there's enough to go forward here, not guilt or innocence, but there's enough to go forward here for the case to get pushed up. But they choose whether to they determine whether to indict an individual for a crime. The grand jury may agree that an individual has committed a crime and return what they call a true bill. That means when they say yes, it's to be indicted, or determine whether evidence does not support the criminal charge and return a no bill. The grand jury may decide to undertake an independent investigation and may issue a presentment or report. The grand jury is technically independent of the prosecution, so they don't work for the prosecutor, they're independent. In practice, the grand jury possesses several powers that make it a particularly powerful arm of the prosecutor. So, that being said, the grand jury is different from the petite jury or the jury and that determines guilt or innocence. The grand jury is a body of about 12 to 20 people, and depending on the jurisdiction, how many they require. But their job is they're impaneled, of course, and they're chosen from voter registration list. So that means being a registered voter does more than just allow you to vote in an election, but it makes you qualified to actually serve on a grand jury or a jury. So this is really where you get to be a part of the political and process, and is surely democratic. It's purely democratic. It's more purely democratic than actually voting, because your vote definitely counts in the grand jury and jury process. Because you're one of a small number of people who determine things, and you get to have a vote. Just like the petite jury or the jury, which we'll get to later, You're one of 12 people impaneled, and and you get to determine directly guilt or innocence. So when it's one of 12, your vote is 1/12 of the vote, and it therefore matters way more than it matters in an election. So it's very important. So the grand jury process, how that works, of course, the indictment. I'll tell you how it works. So the indictment in the indictment process, the DA presents his case in front of the grand jury. He or she does so what we call ex parte. Ex parte is it's Latin for one sided. It means one side gets to present the evidence. So there's no defense being presented. There's just the DA with all the evidence presenting, and that, when I say all the evidence, even evidence that would not be admissible in a trial, evidence that would not come in. So almost it's like the DA gets to bring the entire kitchen sink into the grand jury and say and present it, and then at the end give an argument as to why um, the indictment should be given or a true bill should be rendered. So it's one sided. So now a defense attorney can be in there, but they don't say anything. So they have nothing to do with the process. They just sit in there and listen. So of course, but any testimony given in a grand jury proceeding is still under oath. So those people you bring to testify, to give their testimony at the grand jury, those testimonies are under oath. So sometimes it's good for a defense attorney to be there, so because they can hear what this person's saying, and what they're testifying to. So if the true bill is given, at that point they can prepare for trial, prepare their defendant for trial, because these are definitely statements given under oath, and sometimes these statements, if they're going to be inconsistent with something that a witness is going to say later, you can use that to what we call impeach the witness. So, in other words, if they say one thing earlier and say something different at the actual trial, you can say, "Whoa, whoa, whoa, whoa! You said this in the grand jury setting." So some grand jury settings are actually recorded because, like I said, it is definitely uh, testimony given under oath. So, like I said, there are no rules of evidence. Everything's admissible, and the DA gets to by his or herself give produce or present all the evidence without anyone arguing against it. So honestly, there's probably 90+% indictment rate because there's no one in the room to actually refute or offer um, contradictory evidence to try not to get the true bill. So it's actually a travesty. The case must be very bad when a DA goes before the grand jury and does not get an indictment. So that goes. Let's talk about Ferguson, Missouri. I don't know if you remember Mike Brown. I think this is back in 2013, 2014. Um, but in that case against the police officer who killed Mike Brown, remember, it was highly publicized. The DA came out after he met with the grand jury, and they did not. They issued a no bill, meaning they did not indict the police officer for the homicide of Mike Brown. Um, that was weird because in my line of work, for as long as I've done this, for over 12 years, the almost 12 years, the grand jury pretty much always gets an indictment. The only way they don't get an indictment is almost if they go in there not wanting to get an indictment, and they almost speak badly about their case in front of the grand jury. So it's almost like they're throwing the case. So we call it point shaving when you're trying not to win. Um, so that was the travesty of the Mike Brown case because this guy goes in there with only the evidence against the defendant. He's the only one on the floor that gets to talk. He gets to uh, call any witness he wants to come in to testify under oath. So for him not to get a true bill, and of course, I don't know if you guys remember the press conference afterwards, he said disparaging things about his own case. So it's almost as if he went in there not wanting to prosecute that police officer. So they wanted to at least give the illusion that they were trying to be fair in the criminal justice system and actually prosecute a policeman for the slaying of an unarmed citizen, black citizen, of course. and he goes in there, and they give the illusion that they're trying, but really they weren't trying. And that's my opinion, but I'm not the only attorney who's spoken out on that. But literally, he went in there and pretty much blew his own case, so that it wouldn't be indicted. That's exactly what he did. Kind of technically, it's pretty unethical to me as well. So at the end of it, he could come out and give a press conference, and at the end of the day, the officer was not prosecuted or tried for killing Mike Brown. And now the grand jury is the scapegoat. So he can say, well, we tried, but the grand jury didn't give an indictment. So it kind of got him off the hook, and everyone was arguing about the system as he rides off in the sunset, and that police officer continues to be the police. You see how certain things could happen. So the grand jury process can be it can be abused, it can be misused. So in that situation, it was he didn't try on purpose. Because usually it's automatic. If my case is set to go before the grand jury and I know I'm awaiting indictment, I go ahead and let my client know it's only a matter of days or months before I get the indictment. A notice of indictment or true bill of indictment in my box, and I call my client like, "Hey, your court date's going to change. We're now Superior Court." If I know my case is going to be indicted, or going to go before the grand jury, I go ahead and tell my client to get ready to come to Superior Court and to get ready for the court date change. So it's automatic. So for a DA not to get it, it makes you go, what did he really try? But that's neither here nor there. Arraignment. What does arraignment mean? Once a decision is made to indict an individual or to bind him or her over for trial, the individual is brought before a judge, informed of the charges filed against him or her, and asked to enter a plea of guilty, not guilty, or not guilty by reason of insanity, or what we call nolo contendere, which is no contest. That's just the Latin way of saying that we're not going to contend, or we don't plan to contest the charges. So that's the arraignment. When you're arraigned, that's when the judge asks, "How do you plead?" So you give an answer: not guilty, not guilty, not guilty by reason of insanity, or some other defense, or some other justification, or you say nolo contendere, or what we say no contest. So that's the arraignment portion. Then we go to pretrial motions. Now, pretrial motions, of course, in fact, hypotheticals, as we talked about before, in the writing assignment, we talked about a motion to suppress being made. This is the moment where those pretrial motions, some motions in limine, these motions are filed and presented, and there are usually hearings on these motions. That's the point where now we're trying to keep evidence out if we're the defendant. So we're filing motion. So if I feel like my client's rights were violated, this is the point where we file a motion to suppress the evidence that was obtained from my client's rights being violated. A defense motion the defense attorney may file various pretrial motions, maybe a double jeopardy motion, speedy trials, and hey, we've been waiting too long to be tried. There's been delayed. It's hurting my client. It's hurting our ability to defend ourselves. So either give us a new trial or dismiss the case, or give us a speedy trial or dismiss the case. Change of venue if you feel like it's not just to be heard because it's one of those cases that gets a lot of media coverage in the area. You feel like your client may not get a fair shake in this venue. You can file the change of venue motion. Also, discovery motions after indictment. That's when you're essentially asking that for all the evidence. So once the client's indicted, the right to discovery attaches, at least in North Carolina. So in North Carolina, once my client is indicted, I file motions motions for discovery, which means that I want the evidence. I'm entitled to it. At that point, we can also file suppression motions or suppression of evidence motions, which we talked about, pretrial motions to suppress. So that's where a defense attorney files the pretrial motions. So the constitutional right to a jury trial. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to a public trial. In 1969, in the case of Duncan v. Louisiana, the United States Supreme Court held that the right to a jury trial is fundamental to the American scheme of justice and is protected under the Due Process Clause of the 14th Amendment. A jury trial is required for a serious crime that carries a sentence of more than 6 months. So that's when we're talking about felonies. You can also get a jury trial for misdemeanors, depending on the jurisdiction of where you're at. In North Carolina, Superior Court does not have original jurisdiction over misdemeanors. They'll start in district court. Now, in district court, on the criminal side, you get what we call bench trials, where the judge is ruling on law, but also determining matters of guilt or innocence. So the judge now becomes one person, 12 people, a 12-person jury and one person. So they now also determine guilt or innocence. Now, the way it works in North Carolina, if we don't get the verdict we want as defendants in district court, in a bench trial, we can appeal for what we call a new trial, or what they call trial de novo. What that means is we appeal to get a new trial, where now we're asking for we're going to get that jury trial we asked for, even for misdemeanor. But of course, with felonies, if they get indicted, that's automatic. That jury trial is automatic. Now, there's been recent changes in North Carolina where, depending on certain felonies, a defendant can actually waive the jury trial right and ask for a bench trial, even in Superior Court. Now, I don't think that's the wisest thing to do. I guess it depends on what type of case it is, because what we'll find out about juries is sometimes juries, as democratic as the process is, sometimes you have certain cases where you would rather have just a judge hear it and determine guilt or innocence, because the case may go over the regular person's head. So this may be a case that's highly technical, where now you're asking juries, regular people, to make decisions on a case involving some type of white collar crime that's very highly technical. That not so that's one thing about jury trials. We're asking people that don't know anything, and then we're assuming they don't know anything. Some people do know, but when you pick 12 people out of a pool of jurors, you have to determine whether these 12 people are going to be competent enough to kind of learn what's going on, or what's the facts, and what to apply, what's going on, and make a sound decision, having to learn at the same time. So sometimes in technical cases, it would make sense to do it in front of just a judge, because the judge, of course, we see them as being wise, of course, because they're the one that makes a decision. And they're just as educated as the other attorneys. You got to be an attorney to be a judge. So a lot of times, some attorneys talk to their clients and they opt to take a bench trial over a jury trial. Now, that's only on some cases. That's usually less serious felonies. So people aren't really taking bench trials on murder cases. In murder cases, something crazy serious like that, you probably want to go ahead and get that 12-person jury. You don't want one person determining guilt or innocence in a case that serious. So, let me see. What was that? Okay, so we're talking about Duncan. Okay, a jury trial is required. Oh, like I said before. Okay, I said that. I won't repeat myself. Um, the 12-member jury requirement. Now we're not. Now, of course, now we're not talking about the grand jury anymore. We're talking about the petite jury. This is the jury where now we've impaneled 12 people, or depending on the jurisdiction, it may be less, but we've impaneled a number of people to now make the decision, listen to the evidence, and not grant an indictment, but now they're determining actual guilt and innocence. We're in a trial now in front of these people. The 12-member jury is not required by the Sixth Amendment. In 1970, in Williams v. Florida, the court approved the constitutionality of a 6-person jury. So really, it depends on what state of jurisdiction you're in. Like in North Carolina, it's 12-person jury. So you may go to another state. I think in South Carolina, it's like 6. So it doesn't necessarily have to be 12. It can be as little as 6. So it just depends. But in North Carolina, it is a 12-person jury that's going to be determining guilt or innocence. So a very important part of trial, actually, what I would say is the most important part of a trial, once the trial process is started and you go through the indictment process. But the most important part of a trial is jury selection. This can make or break your case. So you have your case, you can't change the facts. So when I'm representing someone, the facts are the facts. We have all the evidence. I filed my motion for discovery. I get I get the police reports. I get whatever I ask for. Me and my client are brainstorming, talking about how to prepare a defense. Figuring out what witnesses I need to produce so we can fight the case. But I can't make the facts up. The facts are the facts. But then what I can control or try to control is who hears the facts. So the jury selection process is super important because I want to get people that would help my client out in making their decision. And sometimes you can't pick people that are just gonna you can't pick people that are biased or know your client, and we'll talk about that, or know any parties in the case. But you want to pick people based on some questions, and we'll talk about what that process is. But you ask them questions and you try to impanel the jury. Um, the selection of the jury pool from which the jury is drawn is typically based on names drawn from voter registration lists or list of licensed drivers. Several states rely on the key man system, in which the community leaders select individuals from a list, and they put that list forth. So um, individuals are examined by the lawyers in a process called voir dire. So voir dire is a French term, two words, VOIR, voir, and then dire or dire, DIRE, voir dire. So it's French, and it means essentially personal conversation, or to tell the truth. So they may be struck. So in the process termed voir dire, juries may be struck from the jury based on uh, challenges. And attorneys in this voir dire process, we have two tools in which we can take people from the jury. Um, there's challenges for cause, and that's when they so based on challenges for cause, when they are unable to make an impartial decision as to guilt or innocence, or based on what we call preemptory challenges. So there are two types of challenges for cause and preemptory challenges. And preemptory challenges in which the lawyers are not required to offer any reason whatsoever why they want this person taken off the jury. So the way it works in jury selection, so you have this jury pool. These people are called in for jury duty. Anyone that's ever had jury duty, you get this letter saying when you need to report. You report. You sit in the room, and they call you into a courtroom when they need you. So what happens is they call usually a number about anywhere between 30 and 50 people to come sit in the courtroom. They sit in the courtroom, and the attorneys, and we're ready for trial. So everyone's sitting at the table. The judges on the stand, the stenographers in their place, and the clerk is in their place. So everyone's in court, and the jury pool walks in. These 30 to 50 people walk in, and they sit in the gallery. Then the clerk stands up based upon that list that was chosen. They choose they're pre-chosen names that are read out, and you have those 12 seats in the box. They call out and they number the seats. They say this is 1, 2. So they tell the people, and they call the 12 names out, and they have them seated based upon seat number. So they call the name out. Jury number 1, call their name. You sit right there, and they do that until 12 people are in panel. At that point, we're kind of playing. Almost like, I'm trying to think of a name to call it. It's almost like you're a round robin. Each side gets to ask questions, and for either you have what they call the challenges for cause. That's when you, after asking these questions during voir dire, the answers given. If the answers given show the court that this person can't be impartial, meaning they can't be fair, or there's something about the case where they have some type of moral issue with the case, and they can't be fair, they can't do it. If they give you an answer of that nature, then of course the attorneys get to challenge that person for cause and take them off the jury, because whatever they said or whatever answer they gave to the voir dire question lets the court know that this person isn't capable of being a juror. So that's what we call challenges for cause. Now, with challenges for cause, those are unlimited. So both sides in their questioning back and forth and talking to the juries get to have as many challenges for cause as possible, because you don't want people that give answers to questions that show that they're not going to be fair or can't do it. Then you have preemptory challenges. Now, with preemptory challenges, usually those are limited. In North Carolina, we're only limited to sits. That's when we can take a person off the jury for no reason whatsoever. It doesn't even have to be for a cause. It can be we just don't like that person. Now, it's technically not supposed to be based on race or gender. So it has to be based on, you can't have the obvious look of trying to set the jury based upon race, especially if you're a prosecutor. Now, as a defense attorney, we get a little bit more leeway because we're here for one person. Remember, the prosecutor doesn't represent the interest of one person, even the victim in the case. They represent the people. That's why that's what I think I said in earlier chapters. That's why these cases are the state versus or the people versus, because the prosecutor is standing in the place of the people. Because remember, even if there's a victim crime and there's one person you hurt, remember, in the criminal court system, you're being called in to go to trial, and you're being accused of a crime that has violated society or violated the people. So even if there's one victim, you're still there to come in front of the people to say why you violated this code of conduct or this contract between you and everybody else. So the district attorney is really about justice, making sure everything's just and is fair. So the district attorney is never in a situation where they can try to lean a jury or have a jury that's all white or even all black, or all women or whatever. So any jury that looks like that, it's automatically we're gonna look at it and say, on his face, that's not fair and that's not cool. There's some racism going on. But on the other hand, with the defense attorney, we're technically not supposed to pick juries based on color, but we're not here for everybody. We're here for our client. So I want my client, the individual I'm representing, to be in a favorable situation. So if I have a black male jury, it'd be great if I could have a black male defendant. It'd be great if I could have all black male jury, someone that understands what it's like to walk in this black skin in America. So if I'm making arguments in front of this jury, closing arguments, or after I presented evidence, I feel like my message may not rest or land on deaf ears if the jury looks like my client. They can sympathize with his situation. So as a defense attorney, of course, sometimes I will admit I want, depending on who my client is, I want people on that jury that look like him and may come from communities like his, so they may understand what his actions were, what his alleged actions were, and maybe that he didn't do it at all. Um, so where was that? Okay. All right. The Equal Protection Clause prohibits intentional discrimination against individuals in the selection of the jury. And I just talked about this. The Sixth Amendment requires that the jury represent a fair cross section of the community. The question that may be asked on voir dire, the questions that may be asked on voir dire depend on the nature of the charge. In capital punishment cases, individuals may be asked whether they are willing to impose the death penalty, which is important. If it's a capital case where death penalty is going to be asked, you have to let the jury know that, because some people are uncomfortable with making decisions of guilt and innocence in a situation where they know their decision may lead to someone being killed, going to the death penalty, having the death penalty rendered against them. So for some people, that's a very heavy burden. They don't want to be a part of that. So that's very important. But you can ask the jurors in voir dire a lot of questions. What we want to ask is who they are. What do you do for a living? And when I'm doing it, of course, I write the names of everyone that's in the seats and the seats they're in, and of course, I'm looking at my client to get a gauge of whether they like this person or don't like this person. Of course, the prosecutor goes first in their questioning, then I get to ask questions. So as they're answering even the prosecutor's questions, I'm listening to their answers. I'm jotting stuff down. I'm trying to figure out how this person thinks. Like, are they a liberal, or are they conservative, or are they progressive? How do they think? Um, depending on what type of case it is, I may have a case where it's the policeman's word versus my client's word. So a lot of times I may ask them questions about law enforcement and any interactions they've had with law enforcement where they felt like they were unfairly treated, whether it be a speeding ticket. And sometimes those answers, because people will let you know what they think and how they feel in answers to questions. So sometimes they give you an answer, you're like, I like that guy. He doesn't like the cops. It's not that he doesn't like them, it's just that he doesn't necessarily take what the cops say as being truthful. So I want people to at least if I know the case is the cop's word versus my client's word, I want people to at least don't, there's some people out here that the cop said it, that they raised in communities where if the cop says something, it's almost like Jesus said it. It's true. I want people to question and say, not necessarily. I had a situation with a cop where I was pulled over. I was not speeding. I had to go to court, pay a fine, and I wasn't speeding. He didn't, I looked at my speedometer. I wasn't speeding, and I can ask them questions about interaction with police and stuff like that. You can ask general hypothetical questions. Now, you don't want to go deep into the facts because that's trying the case, but you want to kind of ask hypothetical questions like, "Hey, have you ever been accused of something that you know you didn't do, um, but everyone was saying you did it, but you didn't do it? How'd that make you feel?" So sometimes that you get to ask those questions to delve into how a person thinks. So it's psychological. So you're choosing a jury um, based on those answers because you want people to kind of may think in a manner that may help your client. So that's the importance of jury selection. Voir dire is super important because by the time we run out of challenges and that last juror, that once we have that last challenge and everyone's cool, I look at my client, you like everybody, like that's cool with me. And now we have a jury impanel. So people are taken off and replaced. And after all said and done, when the dust settles, of course, now we have the jury and we're ready to go. Now let's talk about preemptory challenge. Each attorney may reject a limited number of potential jurors without providing any reason, as I talked about before. Preemptory challenges may not be used to challenge potential jurors solely on account of race or gender. Of course, that's for both sides, but definitely for the prosecutor because they're supposed to be just. As a defense attorney, I can tell you I don't care about justice. What I care about is the best outcome for this person that's sitting to my right or my left, depending on the courtroom. I'm worried about that. My client. If I'm trying the case, I want people that can see the world through my client's eyes. If my client's a black male, it's great when I have black males on the jury. Or if my client's a woman, and let's say it's a case where it's something domestic where my client had to react to a man that was beating her and she might have killed him or hurt him badly, and now she's in court for some type of assault or even a homicide. I want women on that jury who might have gone through something with a man where they felt defenseless. So I'm asking questions. So if I get an all female jury, that means once the evidence is presented, I feel like there are people on that jury stand that can understand why my client acted the way she did or why she reacted. She was in danger. So if, I may ask questions. Have you ever been in a situation where you were confronted by a male or a stronger person and felt helpless and couldn't fight for yourself? So you ask certain questions like that. They answer the questions like, "Hey, I like that person." They'll understand why my client felt cornered and had to pull a gun out on this man who had been beating her. Um, so sometimes that's why voir dire is so important. Um, so challenges. Let me see. Peremptory challenges. Challenge to judges. Of course, we talked about peremptory challenges. Then there are challenges for cause, which the book doesn't say anything about, but that's important. That's when like I said before, it's when a person answers a question in a manner that shows that they're going to be biased and they can't be fair and impartial, or they can't do the job of a fair juror. If you ask a question and the answer suggests that they can't be fair or can't do the job, then of course you don't have a limited number of challenges there. Usually both sides agree, yeah, we need that person gone. They can't be fair. Um, so, challenge to judges. Judges are required to remove or recuse themselves from a case or may be removed based on their inability to function in a neutral and impartial fashion. That means the judges also can't have conflicts of interest. So, a lot of judges, or almost every judge, practiced law before they became a judge in some capacity. So, they might have been a defense attorney, they might have been a prosecutor, but you'd be surprised when you live in a community, even if you're a judge in that community, if you've been practicing law long enough, you may walk into a courtroom and have to be a judge in a case where, wow, I represented that guy that's the defendant now. That means you can't sit as a judge in this case. There's a conflict. Or you may have been the prosecutor that's prosecuted this guy before you got your job as a judge. That means you're gonna have to recuse yourself because there's at least a look of impropriety. Um, Public trial. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to a public trial. An unruly defendant may be removed from the courtroom, and there is no absolute right of the public or of the media to have access to a trial. So judges can limit media access to a trial. And if it's a certain type of trial where they don't want certain stuff getting in or out, sometimes they can actually close the trial off. Um, to the public. So, but for the most part, that usually doesn't happen. Now, in juvenile cases where you're dealing with juveniles, usually that those cases are usually closed because you're dealing with juvenile offenders. That so essentially they're even if they're charged as an adult in certain situations, the court, because of the age, can kind of close the courtroom off, and the court can also limit the media. So you have some judges that allow cameras, like those big famous Hollywood cases. Some judges allow cameras in, like the O.J. Simpson case was televised. It was like watching TV. You could watch the trial on TV every day. But other judges don't allow that. So the judge has a little bit of discretion in determining how public the trial is going to be. But when we say public trial, essentially what that means is that it's in front of it. You have a jury. You're being tried. You're being tried in front of the people. Um, it doesn't necessarily mean there's an open door policy and everyone can walk in. As a matter of fact, I've seen trials where the judge had to kind of shut down the courtroom or keep anyone from coming in the courtroom that wasn't courtroom personnel for safety reasons. There's recently a trial with some gang members where it was something involving some gang members, and the gang members were coming. The gang members were coming to support their homie who was a defendant, and they were kind of making eyes or kind of threatening witnesses and threatening the jury. So they when everyone comes to court and you look on the left side of the courtroom and is in red, it's like, oh, the Bloods are here. They're trying to, sometimes they can be seen as a show of force to intimidate. So in this one case, the judge literally shut the court down and said no one's allowed to walk in, come in this courtroom, except for court personnel, the people working on this trial. So even as lawyers, we're always in the back hallway. We can go into courtrooms. We couldn't go into the courtroom. So there was a bailiff outside the courtroom to keep it secure, to make sure no one could come in. And of course, there were other bailiffs on the other side of the back hallway to make sure they were like, hey, you can't come in. The judge is closed it off. So there's certain situations where the judge has that discretion. Now the trial itself. The defendant now enters the formal trial stage of the criminal justice system. So they've been indicted. Pretrial motions have been made. They've selected a jury. Now it's time to start the show. The trial starts with opening statements. That's where the prosecution and defense attorneys may make brief opening statements. Now, opening statements are not argumentative, meaning that because now at this point, remember, no evidence has been presented. So you can't really make evidentiary arguments or arguments. So really, what you're doing is you can only as litigants in these cases, you can really only tell them what you plan to present. You can't say anything about the other side because the other side hasn't presented any evidence yet. So you can't really make a whole lot of like crazy arguments. So it's really just an opening statement where you introduce yourself, introduce your client, if you're a defense attorney, and say, hey, here's what we plan to show you today. You can talk about who you're going to call to the stand and what they're going to talk about. And then you can go from there. So it's just kind of giving it's kind of an introduction or a prelude to what you're gonna present. And then you can even end it, and you can say, well, at the end of all evidence, at the end, we're gonna ask you to find my client not guilty. Or if you're a prosecutor, you're gonna say, we're gonna ask you to find the defendant guilty. After the opening statements, you have the presentation of evidence. The prosecution presents the case in chief, and that's when they go. So case in chief is when, as a defendant, my case in chief is when it's my turn to present. But the prosecution, because they have the burden of proof, they have to go first. If they have no evidence, there is no trial because it's dismissed. But the prosecution presents their case in chief. The defense attorney may then cross-examine witnesses. So every witness that takes a stand, that testifies in front of the jury, they get asked what we call direct examination questions, meaning that the side that called them, the prosecutor, asks them questions. When they're done asking that witness questions, that Sixth Amendment right to confrontation, and that's in the Sixth Amendment and the due process. So that Sixth Amendment right to confrontation and direct examination, that means now I get to face my accuser. The defendant gets to face their accuser, and as their attorney now, and sometimes even defendants that represent themselves, they now have the opportunity to ask questions in what we call cross examination. So now we get to cross-examine the opposing witnesses. So they've given their statements, and if we're very prepared, we may have prior statements or prior sworn testimony or something that kind of refutes what they've already said, and now we're going to question them on it. We're going to hold them to the fire and see if we can catch them in a lie, or show the jury that this person is inconsistent and can't be trusted or doesn't know what they're talking about. So that's the point of cross-examination. So the defense attorney then may then cross-examine the witnesses, and the prosecutor has the opportunity to rehabilitate the witnesses. So that's when they get what we call redirect. So after they're cross-examined, the judge will say, "Do you have any more questions?" or redirect, and at that point, the prosecutor can now go back and try to clean it up, because of course, usually after a good cross-examination, the witnesses on the stand and they just got beat up. So they give the prosecution another chance to ask them more questions to see if they can clean it up a little bit. And then of course there can be recross as well, and then there's also redirect again, redirect. So a lot of times judges, sometimes in the interest of time, the judges will cut it, but sometimes the judges will let them be direct examined, cross examined, redirected, recross, so it can switch where this person may be on the stand for a very long time. Um, the defense attorney next presents a rebuttal. So the rebuttal is what we call the defense's case in chief, where once the prosecution has had all their witnesses to testify and presented all their evidence. Now, at the close of the prosecution's case, now it's our turn if we have evidence. Now, remember, the defendant is not under any duty to present any evidence. So the defendant can just sit there and twiddle their thumbs, and we don't have to present any evidence whatsoever. And we'll talk about later on the fact that can sometimes be advantageous, because we'll talk about the fact that by the defendant not presenting any evidence, that leaves the defendant with the last word in closing arguments, which we'll talk about at the end. Something else I was gonna say, yeah. Where's that? So another thing. Now witness testimony is evidence. So what a person wears, how they look in court, what they say on the stand, all that is evidence. Now then you also have the spoken evidence, which is testimony, but then you also have physical evidence. So if it's a murder trial with a weapon, they want to bring the weapon in court, guess what? No physical evidence can come into a trial without being testified to. So the DA or anybody, no one gets to walk into court and say, "This is the gun. Now, holler at your boy." No, they actually have to have someone testify to what it is, how it's connected to the crime. So there has to be a witness. So the only way to get evidence into a trial is to have a witness testify to it. So it's just like Matlock or these shows, when the smoking gun or that piece of evidence that comes in, that evidence has to be testified to. It just doesn't walk itself into court and come into trial on its own. There has to be a witness who's going to testify to the nature of what it is and tell the court how it's relevant to the case and how it's connected, and why it is what it is and what happened, and sometimes even testify to the chain of custody, how it got to be there, how we determined that it was the murder weapon or something like that. So remember that. So testimony is evidence. So what a person says from the stand, and actually how they're perceived, all that stuff that the jury is ingesting, and they're going to use that to make their decision. And what they say is included in that. But also physical evidence, of course, we know that that's evidence as well. But remember, it doesn't get in without being testified to. The defense counsel may make a motion for judgment of acquittal. What that means is, at the end of the prosecution's case in chief, at that juncture, that's like halftime. So it's almost like when the prosecution's case ends, at that point, we can make motions to dismiss. So we can say, "Hey, judge, and viewing the evidence in the light most favorable to the other side, the side that's just presented the evidence, even if you view it in their favor, guess what? It's not enough. It doesn't meet the burden, not even necessarily the burden of beyond a reasonable doubt, because you're not there yet. But there's not even enough evidence to go forward, Your Honor. They didn't present. So especially there's some situations where the prosecution, in their haste, trying to move too fast, they may forget to present evidence of a very important fact that has to be presented in evidence. So remember, criminal cases, the definition of crimes are usually set in what we call elements. So that means there's certain things that have to be testified to or put into evidence, and every element at least has to be evidence for every element has to be presented. A good defense attorney is marking that down to see, oh, did they say what they're supposed to say? No, they didn't offer any evidence to that. Like in the case of assault on female in North Carolina, assault on female, of course, what that means is to be guilty of assault on female, a male that's 18 years or older that assaults a female. So that means in evidence, they just can't walk in and say, "Yep, did he hit you? Yeah, he hit you." Well, that's assault. The state rest. They actually have to present evidence that shows that this man is 18 years or older. I don't care if he has a gray beard looking like Santa Claus and he's 90. They have to present evidence of that. If they don't put any evidence on that evidences or proves that this person is 18 years or older, then that's an element that they left out, and that is an essential element to the case, to the charge of assault on female. So at the close of evidence, I can say, Your Honor, you've listened to everything all morning. They said this, they said that, but guess what they didn't say? So because they didn't present any evidence, and you as a and the jury can't just on its own determine that this person is 18, it has to be presented in evidence. Guess what? We're going to ask you to dismiss, and the judge has to dismiss at that point because the prosecution has the burden of proving every essential element of a crime. So fair to do so in their case in chief. Once they close and say that's it, at this point now I can make that motion. And it would in that situation it would be granted. I just had a trial. It was a bench trial, but I just had a trial like last month where that happened. Where I was the DA, I was looking. I'm like, so he's not going to talk about age. I'm definitely not going to tell him that he needs to present evidence on the age. I'll just let him roll. And he kept rolling. And he said, "Well, the state closes." And I said, and I promptly rose after I made sure he was closed and had nothing else to say. I said, "Your Honor, I'm making a motion to dismiss based on the light. If you view the evidence and everything presented in the light most favorable, we call it the non-moving party, meaning the party does not bring the motion. So if I'm bringing the motion and I say view the evidence in the light most favorable to the opposing side or non-moving party, that means even if you look at it and you look at it favorable to them, if you take everything they're saying to be true, guess what they didn't do? They didn't offer evidence of an essential element. So in that case, he didn't offer evidence of my client's age. And the court in that situation is not allowed to take what we call what they call it judicial not allowed to find judicially. Even the jury can't just say, yeah, he's obviously 18. No, they have to actually present evidence of that. So my client walked out. It was dismissed at the close of the state's evidence. So that's how that works. Okay, in the event that the motion is not granted, the defense may then present various legal defenses, and that's where we can, try to see if we can get it dismissed without it going to the jury, even with defenses. The defense may then renew the motion for a judgment of acquittal after the defense. So after the state is closed, let's say if our motions to dismiss aren't granted, then it's our turn. So now it's the defense's turn to present their case in chief. Like I said, as defendants, we don't have to say a word. So we don't have to say anything. So we can literally go in there at the end of their evidence and say, oh, we have nothing to present. And we can just talk about in closing arguments how bad their case is and how they haven't proven beyond a reasonable doubt that my client did anything. Of course, if we do have a defense, it's not the DA's job to prove the defense for us. Now, sometimes they may call a witness that says something that actually helps us. So in that situation, sometimes I may look at my client and say, "Hey, you might not have to testify because guess what? They're hurting themselves. They're messing up their case." So in that situation, we may be able to make arguments in closing to actually get an acquittal. But if we do present evidence, the same rules apply. We put witnesses up. We direct examine our witness. The prosecution can then cross examine all of our witnesses until everyone goes. Same rules apply, of course. No physical evidence gets in without first being testified to, so that all applies. And then once we're done with our case, That is the close of all evidence. And at the close of all evidence, of course, now they put on evidence, we put on, and we made motions. The motions weren't granted, so then we had to go forward with our evidence if we had evidence to put on. And then at the close of all evidence, when we're done, guess what? Now we can say, Judge, you've heard everything. Now, based upon hearing everything on both sides, we're asking you again. We're renewing our motion to dismiss. So we state the same arguments. So we're saying now, Judge, you've heard the whole story. Now, based on the whole story, is there enough here for you to allow this case to go to the jury? We're asking you to dismiss. Now, of course, the standard of proof at that situation when we're on a motion to dismiss is not. It's actually not beyond a reasonable doubt. It's actually it's not quite, but by preponderance of evidence, it's more like a probable cause standard. Like, did they present enough evidence to go forward for a jury to even have to determine guilt or innocence? That's what we're asking. Um, so the defense may renew the motions for judgment or acquittal, or this what we call a motion to dismiss. The prosecution then may present rebuttal evidence. So in certain situations, if the motion is not granted, then of course the prosecution can present rebuttal evidence. Most of the time, if they once they've closed and then we've gone, sometimes they allow them to now offer rebuttal evidence, meaning they get to kind of open their case in chief back up again and then present evidence. So confrontation. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him or her. This applies to all phases of the pretrial and trial phases and sentencing. So what that means is there's confrontation. That means you have the right now to cross-examine, to confront and cross-examine. So that means a person, if they're going to say you did something in a trial, they got to show up and testify against you. They can't send in a piece of paper or an affidavit saying this is what he did. No, because guess what? The opposing party can't confront and cross-examine a piece of paper. So that statement saying that he did it or he hit me is not going to be enough on paper. That you have to come to court and confront him and say he's the man, he hit me. And that means once you confront him, that also now gives the defense the right to now question you and cross-examine you. So that's the importance of confrontation. Imagine how unfair it would be if a person could accuse you on paper and just walk away and it actually be able to be used against you in court. And that's where we have what we call hearsay, or out of court statements that are used against you that you can't cross-examine because the person that said the statement isn't there for you to question. So cross-examination. The cross-examination of witnesses is central to the confrontation clause. Hearsay is testimony that repeats a statement made by another person that is offered into evidence to prove the truth of the matter asserted, but that person isn't there. So there's someone else saying what someone else said, but that second someone else isn't there. So what that means is a person can't come into court and testify to what someone said and that person's not there because of confrontation. If someone's saying something that my client did, they have to be there to say it. If another person can come in and say what someone else said, how's it going to be fair? How am I going to be able to cross-examine what that person actually said? So it now becomes a confrontation clause issue. So of course, I want to be able to cross-examine any statement that's made against my client. So that's kind of the basis of hearsay. We don't go into the full hearsay rule, but it is an out-of-court statement made by a declarant or person that's out of court that's being offered, that's not in court. But that statement that they made out of court is now being offered to prove the truth of what the statement says. So now it's been offered in the court. So if a person says, "Yeah, I saw boys kill that boy," so let's say a person gets on the stand and says, "Yeah, I saw Johnny the other day," and Johnny said he saw boys shoot that man straight in the face. Now, this person is testifying as to what Johnny said. Yeah, they might have actually heard Johnny say that. The problem is they're testifying that Johnny said I said something, but they're not there. So one of the basic functions of cross-examination is that whoever says something against me, they have to be there so I get the opportunity to cross-examine them. If that out-of-court statement, that hearsay statement comes in, how can I cross-examine it? That means the statement gets in and no one gets to check it. So that's what confrontation means. Um, Hearsay violates the confrontation clause because the person who made the statement is not subject to cross-examination. The U.S. Supreme Court, nevertheless, has held that the confrontation clause permits the use of hearsay under certain limited circumstances. So what that means is there's a general rule that hearsay is not allowed. But guess what? For every rule, there's an exception to the rule. So there's certain exceptions to the hearsay rule, and there's certain things that look like hearsay, but they're not hearsay, and it depends on why they're being offered into evidence. So the hearsay rule has like it's two prongs to the hearsay definition. It's that out of court statement made by someone that's not there that's being offered into evidence, but the second prong is why it's being offered. So it's being offered to prove the truth of what's said. Now, if it's been offered into evidence for any other reason, like not to prove the truth of what's said, but just to prove something else, like maybe the person that said it was alive when so if I heard him say something, he wasn't dead. So maybe for that reason, it can be allowed in as an exception to the hearsay rule, or something that's not hearsay because of why it's being offered. Um, we talked. So hearsay, and the book goes deep into hearsay. Hearsay involves a witness testifying as to what someone else said outside of the courtroom, which is introduced to prove the fact that is involved in the case, or the fact of what is said, the truth of what they're saying. Hearsay evidence violates confrontation clause because the person who made the statement um, is not subject to immediate cross examination, and there is no way to test the accuracy of the statement. So you see how it's unfair. The U.S. Supreme Court, nevertheless, has held that the confrontation clause permits the use of hearsay under certain limited circumstances. So I kind of repeated myself with that, but that means there are exceptions to the hearsay rule. But we won't go into all those because that's a whole class in law school. So compulsory process. The Sixth Amendment compulsory process clause provides defendants with the right to obtain witnesses, documents, and other evidence required to challenge the prosecutor's case and to present the defense's case. So that's what we call compulsory process. Means that's what we call discovery. That means they constitutionally have to give us the evidence, or the ability to do our own investigation based upon what they have in evidence. Burden of proof. The adversarial system places on the prosecution both the burden of going forward and the burden of persuasion, or proving and establishing the defendant's guilt. And of course, what we know in criminal justice system, that burden of proof is beyond a reasonable doubt. Now, what does beyond a reasonable doubt mean? Now, in North Carolina, beyond a reasonable doubt is defined as whether or not the jury or the let me see, whether or not the jury is, based upon the evidence presented, is fully satisfied and entirely convinced. So you got two adjectives: fully, entirely. So what that means is, in order for a jury to find someone guilty, they must be fully satisfied and entirely convinced of a person's guilt based upon the evidence. Now, fully satisfied entirely, if you can think of a cup being full, either it's full all the way to the brim, nothing else can fit, which is like 100%, or it's entirely, which is 100%. So if we have a pie and you want the full pie, that means there's no crumbs left. You want all the pie. If you want the entire pie, fully and entirely, you want the entire pie. That's the whole pie. That means if a crumb is left out, that is not beyond a reasonable doubt. So sometimes we give them a little leeway and say maybe 99.9%, but that's still a whole lot of pie. So I can make an argument against the prosecution's case just based on one crumb that wasn't on the pie. So a lot of times in closing arguments, I try to harp on that one thing they didn't prove, or that one thing that there's not enough evidence on, or that the jury can't really make a decision on, because guess what? It's not there. Or ladies and gentlemen, the jury, that doesn't make sense. Even if you tried, you can't make it make sense. So find my client not guilty, because it's not your job here to make anything make sense. It's their job to persuade you that it makes sense. So if it doesn't make sense, you got to find my client not guilty. Just like in the O.J. Simpson case, one of the greatest closing arguments, Johnny Cochran said, if it doesn't fit, you must acquit. So what he was saying is that there's a crumb, and that crumb is that this glove doesn't fit, so it doesn't make sense. So you must acquit. Now, a reasonable doubt. The jury is required to find the defendant guilty beyond a reasonable doubt. I just explained what reasonable doubt is. Closing arguments. I just talked a little bit about that too. Now, closing arguments are different than opening statements. Following the presentation of all evidence, the prosecutor and defense lawyers surmise their cases. Now, once we get to closing arguments, these are no longer statements like opening statements, because guess what? Once we get to closing arguments, all the evidence is going to be presented has been presented. So now you have something to base an argument on. So you can actually argue. You can talk about why he's a liar, he's wrong. You can't trust anything he said. He gave an inconsistent statement earlier, so we don't know which one is true. So, ladies and gentlemen, the jury, you can't believe him. Um, this person testified that this is the gun that was used, and they're trying to link it to my client. But there's an imperfect chain of custody. We don't know if this was the gun. It's imperfect science, ballistics. So we can talk about everything that doesn't make sense. That's what defense attorneys do. Um, in their closing arguments, or what they call a summation. The prosecution makes the same arguments, but they say, and this is why he did it. He was there, he had the opportunity, he was present, his fingerprints are there to try to make a person guilty. So of course that's when you get to be dirty, get downright dirty and fight and make these arguments and actually talk junk about witnesses on the other side, why you can't believe them and stuff like that, why they might have had a bias. Even when mamas get on the stand and say, I saw him, he was at my house at night. Then you have at the end of the case, what do you think the prosecution says? They say, of course she's going to come to court and say that. That's his mama. She doesn't want to see her son go to jail. She would lie for him. So a lot of bad things are said, and people are vilified in closing arguments. But that's the nature of the adversarial system. Um, Jury instruction. So once closing arguments are done, the jury makes instruction. Now I'll go back to closing arguments real quick. Remember I said if the defendant does not present any evidence at the close of the state's evidence, of the prosecution's evidence, there is of course, there is a advantage to doing that in certain cases. For one, anytime a witness goes on the stand, they can be what we call it impeached. Impeached based upon prior inconsistent statements, or they can be impeached on their trustworthiness. So you can bring up a person's record. Or what have you been accused? What have you been convicted of in the last 10 years that carries a sentence of this, or that? So you can kind of open up the record of a person, not to prove that they committed a crime, but to prove that, hey, can you trust this person? They were accused. They found guilty of larceny. They're a thief. They got fraud on their record. So it's not to prove that this person has a propensity to commit this crime in hand, but it's to prove that whatever this person testified to, you shouldn't trust this person because they're a criminal. They're not trustworthy. Personally, I don't necessarily agree with that rule allowing it to happen, because they can kind of mix the jury up. So now the jury is making decisions based upon what the client's record is, as opposed to what actually happened that day. So even though it's supposed to, those type of questions, or that's presented to show that this person is not trustworthy, it goes into it's dangerous, because a jury can be misdirected and make their decision based upon a person's propensity to commit crime, and now that means they're guilty of this one. So a lot of times I have to tell my client, well, you do have a long rap sheet. If you get on the stand, this can be opened up. They're gonna question you about it, because they want the jury to know that you're a liar. But once this gets presented, it'll be more than about whether or not you're a liar. It might go to whether or not you committed this crime, because it's going to look like you're a criminal, and they're going to say, well, if he did that, he did this. So something that is a danger. I don't necessarily like the rule, but I have to tell my clients that, hey, you might want to be careful putting on evidence, or even getting on the stand. Sometimes my client is all the evidence I have, because they may be the only witness. Now, a situation where I have other witnesses that may be able to tell the story without my client getting on the stand and getting towed down, um, I'll let them testify. But there's some situations where it doesn't make sense for us to put on evidence at all. If the prosecution puts on a case and the case just totally sucks, there's so many doors that aren't open, there's so many ends that don't meet in their case. Sometimes I can just say the case speaks for itself, the thing speaks for itself. So I can just make an argument without anyone testifying. And the advantage is that if I don't put on evidence as a defense attorney or as a defendant, guess who gets the last word on closing arguments? I do. That means the last voice that the jury hears is my voice saying, find my client not guilty, and here's why. So there is an advantage to being the last voice. Now, if I do put on evidence, I get to be heard, but guess who goes last? The prosecution. And the one thing about closing arguments is an art form, because if you're going second and you're waiting on them to go first, you get to hear what they say. You get to jot down. Let me see how I can twist that and say, nope, that's not true. He says this, but that doesn't make any sense. So you get to, so there's an advantage to being heard last because you get to kind of preach that sermon to the jury and say why what they said is stupid, why it makes no sense. And sometimes, everyone has a slogan they start with, and you can kind of flip that slogan against them in front of a jury. So there is a advantage sometimes to being heard last. So sometimes not presenting evidence as a defense attorney leaves me with the advantage of being heard last. And like I said, I had one case, a drug dealing case, where my client, and we didn't put on any evidence, but the state's case was terrible. They set up this drug sting where they had an untrustworthy informant go buy drugs. The whole buy was like probably almost 200 yards away. These guys were looking at it. They didn't take any pictures. The cops were on the other side, across the street, looking at the transaction. The transaction didn't take place in open air, so it wasn't like it was open where they could see my client. A car drove up. The buyer or the informant gets into the car, and there, so there's a car probably 150 yards away where this person gets in the car. They're in the car for an amount of time. They talk. I guess there is a transaction, and the person buying the dope gets out of the car. Of course, the person selling the dope drives off in the opposite direction. So it's not like the person drove where they could see, oh, that's him in the car. He drove off in the opposite direction, 100 yards away. There's no photographs taken. They didn't even use binoculars. They were just like, we sat there and saw. It's just stupid. There was nothing to enhance, but there's nothing for them to say that my client was the person driving the car that made the transaction. So I got to talk to the jury about everything they didn't do. Matter of fact, I told the jury, don't just pay attention to what you hear and what has been presented. Pay attention to what has not been presented and why it makes no sense. What these police set up this elaborate sting, and they wanted to get this guy, and they had a whole drug deal. They had a whole drug addict go and make the buy. As a matter of fact, during the trial, the drug addict, guess who didn't show up? I don't know if my client made him not show up, but he was scared, but he didn't show up to testify. So they couldn't even get the testimony of the person that bought the dope and saying that, because of the hearsay rule, remember, they couldn't even get his testimony into the trial to say, yeah, when he got back to the car, he said it was Ace. Couldn't even get it in. So they were hurt with that. But then not only that, the cops on the stand were almost talking junk. They would say, yeah, when we got the buyer or the informant, we talked to him. We said, hey, we know you on crack. Don't you shake us down. We're gonna give you this money to buy the dope. You go over there and buy it, and we're gonna trust you to come back because we know how you are. We don't trust you. So they were testifying to that in court. So I'm like, oh, this man they relied upon isn't even trustworthy. So even if he did come and say that it was him, why would we trust it? So they kind of killed their own case. So I'm looking at my client who had a long rap sheet. I'm like, you're definitely not testifying, and he would have been the only evidence we had. So of course, we chose not to put on any evidence. So in closing arguments, I got to talk crap about their case, and we won. So we, without presenting any evidence, because we didn't have the burden of production, any burden of proof, we literally, I was able to kill their case in closing arguments, and I was the last voice they heard. As a matter of fact, I had jury members nodding their head like, "Yeah, you're right." Like, you're right. I had them like, you're preaching, and you feel like, oh, they're getting it. They were listening to my sermon, they were eating it up, and I was like, "We're going home. You're going home today," and he did. Problem is, he actually was a drug dealer, and they had another case working, and probably within 6 months, this time they did have tape and everything they needed to convict him. So some people don't learn. That's closing arguments. Now, jury instructions. After closing arguments are done, then we have jury instructions. The judge issues instructions to the jury before they adjourn to discuss the defendant's guilt or innocence in the closed room where they're deliberating. During the jury deliberations, during the jury deliberations, juries ordinarily may have a copy of the charges and the law that applies, and the judge's jury instructions, so they'll know what they're supposed to do and what they're supposed to consider. And of course, even before jury instructions, after closing arguments, we let the jury leave court, and we actually have a hearing based and determine what the jury instructions are going to be and what's going to be included in the jury instructions. So sometimes that hearing by itself can be hours upon hours because there's certain things we want the judge to put in the jury instructions most states, especially North Carolina, we have pattern jury instructions, things that are in a book that we can either have included or taken out. But we have a whole hearing on that stuff. So once we're done with that hearing and we determine what the jury instructions are going to be at that point, then and we all agree, that's what the jury sent back there with those instructions. As a matter of fact, the judge reads the instructions to them, and they can get a copy of the instructions so they'll know or have guidance in making their decision, and deliberating. Jury unanimity. Sorry, I didn't say that right. Unanimity. That means unanimous. In 1972, in Apoca v. Oregon, the U.S. Supreme Court held that the Sixth Amendment requirement of jury unanimity is not incorporated into the 14th Amendment. That means in some jurisdictions, the jury's decision doesn't have to be unanimous. Sometimes if it's a 12-person jury, in some jurisdictions it can be 10-2 or 9-3 for guilty, and that's all they need. In the companion case of Johnson v. Louisiana, the court actually upheld a 9-3 verdict. In North Carolina, however, it has to be unanimous, so everyone has to find them guilty. It has to be 12-0. If not, sometimes the judge, if they're 11-1, depending on how close it is, it can be declared a hung jury in that situation. Now, hung jury is a win for us, and it's a loss kind of for the prosecution. That means they couldn't prove their case beyond a reasonable doubt and convince all 12 people to find the defendant guilty. So they have the option to retry it or whatever, but in most situations, when they take that L, it is what it is. They don't want to waste the resources of doing it again. Jury nullification. That's another thing we always like to have put in jury instructions. What jury nullification means is that the juries, in their power as juries making the determination of guilt or innocence, the juries actually have the right to ignore the law and say, "Hey, we know this is what they said he did. This is the evidence, but guess what? We like this person, and even though there's not really a justification on the books, we feel like this person was right. So we're going to ignore and we're going to find this person not guilty." Now, they can't use it to find a person guilty, but they can be nullified and find a person not guilty. A jury may disregard the law and facts and acquit a defendant, literally. So that jury is all powerful. The judge can't go back and make them find a person guilty. Once they say not guilty, that person walks away and they're guilty, even though evidence may say this, and my client may say, "Yeah, I shot at the person." They may not have necessarily the best legal justification, but sometimes juries say, "Well, yep, that person did hit his mama." So, in the hood, that's worth killing somebody, even though it's not technically a legal justification. Doesn't give you the right to kill somebody. We like this guy. We feel like he should walk. We feel like he should walk, so he's not guilty. That's jury nullification. So as a defense attorney, I always want that to be in the jury instructions. What that means is the judge actually informs the jury to get, hey, at the end of all evidence, at the end of everything, you as a jury are all powerful, and you can be nullified. You can decide not to follow the law and say he's not guilty. So some jurors don't know they have their options. So of course, as a defense attorney, I want the judge to put that in there because it is pattern. It is a pattern jury instruction. So I want that in there. Guilty pleas. Now we've talked about trials, right? This is the one thing that kills all opportunity to ever go to trial, and this is guilty pleas. Most guilty pleas are done before the trial begins, before we even get there. And sometimes they're done in the middle of a trial. Sometimes a trial goes so badly for a defendant it's looking ugly, and we say, hey, we can save some time. I might be able to negotiate because this ain't looking good. We may be able to stop it from going to a jury. I can talk to the DA, and the DA I can say, hey, we'll end this right now. We'll plead guilty to this if you give us this. And sometimes the DA say, okay, I'll give you that. And we say, hey, we've decided, of course, outside the presence of the jury, we say, hey, we're going to enter a plea of guilty to this or that. We made a deal. So deals can be made all the way through the trial process. Because guess what? No one really wants to go to the end, because guess what? Going to the end can either be a win for one party or the other. Sometimes a case can be so bad for the prosecution, and they see that it might get ugly because they want to get some type of dub. Sometimes they'll say, while they're getting towed down in their case, during a break, they may say, hey, you know what? We're offering a misdemeanor. Will your client take that? And I've had situations where my client was like, a misdemeanor? No, just probation? Okay, I'll take that. Sometimes that's telling. Gotta let you know. Maybe my client did do this. If they're willing to take a misdemeanor. Um, so trials can break down because deals can be made either before a trial or in the middle of a trial. So guilty pleas. The majority of criminal cases are not brought to a trial and instead are disposed of by guilty pleas. Now, majority is kind of being um, very light on that. Actually, not even just a majority, more like 95+% of cases are pled to. Matter of fact, when I go to court every day, matter of fact, I've been practicing law 12 years. Did it as a public defender. Did it, and I'm in private practice as a defense attorney the entire time. And literally, I can tell you that in a year, I average maybe there's some years where I don't have any jury trials. Matter of fact, this is 2019, and right now we're in July. I haven't had a jury trial yet. In July, I got 5 months left after this month to get a jury trial in, and I might not ever get to a jury though, because most things plead out or dismiss. So, and my job as a defense attorney, because a lot of times a jury trial is a risk. A trial in general is a risk. Even if my client is not guilty, but going to trial, remember these are 12 people that don't know what's going on, and they can mess it up. So sometimes it's not in my client's best interest to take that risk, and sometimes my clients don't want to take the risk. Sometimes, so what I'm trying to do is see if we can get the case taken care of without going to trial, or get it dismissed without going to trial. So I present all the evidence I can. I'm talking to the DA before we get to this point, and sometimes the DA say, "Hey, yeah, you know what? That fact does hurt us. I'll dismiss it." Or they say, "Oh, that fact hurts us, but what about this?" Well, because there's a mitigator, you know what I'll do? I'll reduce it and see if your client will take that. So the whole process before we get to a trial is a whole bunch of bargaining, talking back and forth to see if we can settle the case without going there. Um, so that's why most cases, 95+% of cases in the criminal justice system are pled out or dismissed before trial, depending on what the facts are. Um, Individuals agree to plead guilty in return for dropping the charges for a lesser sentence or for or for a lessened sentencing recommendation. So usually we call them scripted pleas. Scripted pleas is when we're pleading guilty to something and the punishment is written out. So it's a contract between the prosecution and the defense, and we have a contract saying this is what we agreed to. Now the judge can either accept it or deny it, but if the judge denies it, um, he can write that I denied it, but we can go somewhere else and do it to another judge. But that's our contract. So most of the time, the judges don't want to get in the way of the work product of the attorney, so they'll just accept it. Um, the U.S. Supreme Court has upheld the constitutionality of plea bargaining. That's what I've just been talking about, bargaining back and forth. Um, the trial judge is required to ensure that the defendant entering a guilty plea understands the element of the charge, meaning they know what's going on, they know what they're charged with. Uh, they also know the facts required to establish the charge, and that the plea is entered voluntarily and knowingly, meaning that do you know what you're doing? So there's a whole plea transcript where they ask that question. Um, I know it was a long chapter. That is the longest chapter in the book, number 13, because it talks about the whole process. But that is the trial process. In a normal class where I'm not teaching online and I'm in person, it usually takes me 2 classes to get through chapter 13. I usually break it up. But of course, we're doing this in one session. So I've taken roughly an hour and 20. It'll be an hour and 20 minutes before we're done. So that is chapter 13. That's a lot to ingest. Watch this carefully. Read the book. Read through the chapter. Fun chapter. I hope I've given you some stories and anecdotes to help you understand it. But that's how it goes. So you guys take care.